strength like no other reaches to me.
Well, a pleasant good morning and welcome to the CCG Hour. It has been a long-awaited morning, I trust, but before I go there, I love to interfere with my guests, especially when they can take interfering with. Anyway, it's really good that we can be here this morning. I thank you for dropping in today, because we have a lot to talk about, because it's been a little while since I haven't had this guest around. She's been just busy, that's all. I'm really happy to have her. Naeisha is with me this morning. Good morning, Naeisha.
Good morning, Wendy. Good morning, viewers. I'm so grateful to be here, and as usual, I love to talk anything law, so it's always fun, and the time goes so fast.
Yes, I know, and I have a feeling that because of where we're going this morning, it's going to go maybe even faster, if that's possible, because we are going to continue to talk about wills. Oh my, for those of you who caught our last program, which was quite a while back.
Yes?
Yeah. We didn't get very far at all in that will.
No, not at all.
But just because there was much.
Who knew there was so much to talk about when you're preparing for your death?
Oh, I know. Hey, hear this. I don't know if it's, well, actually it's a joke. I can still give it. I kind of made it up myself. So I was teaching a group of persons in administrative assistance in this program that I'm teaching. And I was saying to them, I can't remember how we got there, but I was saying to them, I said, oh my, can you imagine if Otway and Lokwa and Wayne begins to pray, if they're, believers, and they begin to pray and ask God because things are dead by them, and money is not coming in. I said, can you imagine they're going and saying to God, Lord, please send us more clients. They all stood there, they looked at me, they're like, Miss, you have to make that joke. But what I'm thinking with that is we tend to treat death and all of it as though, oh my God, we're not supposed to think about it, we're not supposed to have anything to do with it. But it is just so much a part of life. Because if it is, as I said, that, Lokwa and Wayne, and if they have to pray, I mean, they need a living as well. But the sad thing is for them to make a living,
put their petition
before God. Somebody has to die for them to be able to live and for their families to be taken care of. And I said, oh my goodness. Now, the thoughts that come to your head sometimes, and it's like, oh my, yeah. But nobody wanted to think that they would have to pray and ask God to supply for their need, and that it would affect somebody else to get it. And I'm like, So, yeah, we are at that time where we're talking preparation for death.
Yes. And it's an eventuality, and we all pray, we always think about heaven, we want to get there, we want to be with the Lord, and we are terrified of dying. It's the only way. So, but while we are alive, there are definitely things we can do to prepare ourselves for our transition. It's better to call it a transition
but
as opposed to death, because we are afraid when we hear the word death and dying. And we also think that once you're making preparation, it's immediate, it's going to happen. If I talk about making a will, it means I'm preparing for my demise soon. So I just have a few more weeks to live. So it's better
for me to leave it alone.
You leave it alone and leave that for the people who are dying. So if you are sick, then you could talk about that. But if I'm well, I shouldn't even consider it. And I think that's a problem that a lot of folks make, and that is probably why when people die, there is so much chaos.
Yes.
Because you have relationships sometimes when a husband and wife may never have spoken about what will happen when any of them go who predeceased. And sometimes it's a mess when they've gone because no one knows all the information. Sometimes they may have had properties that the other partner does not know about. And it's not because they were hiding anything, but it's just that it just never came up.
It never came up.
You're basically having a good time, you're going out for dinners, and dancing and you go to the show and this concert and you're going to church and you're raising the family. And sometimes people don't talk about everything.
Most people don't talk about
Yes, they don't talk about, I had an account when I was 20 at this credit union. I mean, I met you 20 years later.
Right.
You never mention it. So then the person has to go around and try. If you didn't mention it in a will, you have to go to every institution to get information.
Really? So that...
Okay. Because it's not readily available to you, one. If they have not itemized what are the assets, what are the accounts that they hold, in which institutions, which are the shares that they hold in which institutions. In a will, the document will provide all the details. And if they did not put all of what they own in that will, there'll be some properties that will not be mentioned in the will. And we'll get to that some point when you're going through the will.
Okay, so don't interfere with that now.
Don't interfere with that now.
Because you got me picked up already.
That is way down in the ending.
Yeah, because you got me picked up already.
But definitely what happens is you now have to go through to find out what this person owns. And sometimes you need monies for a funeral. And, people often call you. Sometimes the banks obviously would get their legal advice. They ought not to discuss anything with someone who comes in and asks them about a client's account if they have an account, because all these are privileged, confidential information. And confidence does not end or die when the person dies. So it is only after you have applied for your letters of administration or you've applied for a will. I think we'd have mentioned the letters of administration
just in briefly,
previous
so
program.
Yes.
Just briefly, just as a header to say that that is what you would apply for if you didn't leave a will. So you die intestate. You did not make a will. You die testate when you've made a will. So once you've made a will, you would get a probate, and that is used at the bank. If you didn't leave a will, you get a grant of letters of administration. Okay. That's another process.
So can we go there a little bit more? Just this whole letters of administration.
Yes, we can. We can just briefly elaborate on what really is. Yes. So when someone dies, they can either die testate or intestate. And for the purpose of explanation, intestate is when you did not make a will, a last will and testament in which you disposed of your assets, right? And once a person dies, whatever they own will have to be disposed of. Right. There is legislation, the Intestate Estates Act. I can't remember the chapter right now off my head, and I'm sure it's there in my brain. But basically, it will tell you the order of priority of how to dispose of the assets, and it will also tell you the order of priority of who is to apply for the grant of letters of administration. So that if someone dies and they have no children, no husband, no wife, it is a parent that will apply for the letters of administration.
So if they have nobody
and the law would give you different orders of who will apply.
Oh, okay.
Right? So it will tell you whether it is a spouse who applies, whether it is a child who applies, whether it is a parent who applies, whether it's a brother or sister who applies. It will tell you who is in order of the priority.
Right.
And it will also tell you how you benefit. Okay. So if it is the children that would get all of what you own, or if you have a spouse and children, one would get the half share and one would get the remaining half share. Okay. But that Intestate Estate Act will itemize exactly how the property is divided.
Okay, but so just a little bit to go back. So if someone dies intestate, who is this? I don't want to use the word random, but who will be the person? How will they even get to know about this letters of administration?
They will go to an attorney.
They will just automatically go, right. That will be the only sensible thing to do.
Because once somebody dies, the thing that you must know is that even when someone dies, life has a way of continuing even after you've died. But you are not physically here, but your assets are here, and other things are here. It's almost like
all your debts.
Your debts are here. You still owe your creditors monies. You may have judgments against you from in the court. That is still there. You may have a mortgage from the bank that was not paid off. So these things continue, and there must be somebody appointed, living on, to continue dealing with those affairs.
Right.
So whether it is the administrator may have to liquidate assets, sell a piece of land to get monies to clear off debts and stuff in the that are unpaid. And other things. There might be a trust to be set up for the children because the children might be minors, and therefore somebody has to be appointed to take care of them until they reach
a certain age,
adulthood, you know, majority. So, for instance, you have to take care of their education and other things.
Right.
And the estate may have monies, and you want to ensure that these children are taken care of right up to the adulthood, but they cannot hold it for themselves because the child cannot manage the account, an account in the bank.
Okay.
So an administrator or trustee will have to be there to deal with the monies, dispersing funds, sending funds to the institution, school, or even to university, and different things like that. So I'm saying all of that to say that when somebody dies, there are things left to be done, right? They may be the sole person on their mortgage, but they may have a wife and children, so they will have to basically take that over, so to speak.
Okay.
But it's not in their name. They did not have a contractual relationship with the bank. So
exactly.
It's not automatic.
Right. So that brings me to just taking from there, and just for clarity, and maybe it's a question that, you know, some viewers and listeners might have. If it is that, especially based on this whole letters of administration concept, if it is that, let's say, I may have 2 children, they're minors, I do have some money there, but of course, obviously, even if nobody knows maybe that I have it, because although I have brothers and sisters and whoever, maybe they and I are not doing well at all. So
sometimes
I don't
you're
want
doing
them.
very well and you just don't.
True, but I'm talking about especially when
Yes.
I don't want anybody, you know, there are people like that. I'm sure you know a lot of.
Yes.
I don't want anybody in my business. So, but I'm there now. I have died, and these 2 children, or how much ever children I left, though I have monies in the bank, nobody else knows about it because, I didn't want anybody to know my business. So who now? I mean, I understand that the act would have said all these things, but and especially in our Grenada context, people might have money that they have there, and then nobody knows. So let's say you take these 2 children, because maybe you're in the midst of it, maybe you knew, maybe you are a neighbor, and you're like, oh Lord, I don't want to see these 2 children suffer because when they die, you know, and although she was a woman that didn't used to have anything much to do with anybody, the children shouldn't suffer. So you take up these 2 children. Nobody even bothers because of the way I used to treat with everybody.
Right.
So you have my 2 children. Is it now that you can go to a lawyer to explain? Do you have any kind of rights inside of that?
Definitely someone needs to go to an attorney.
Clearly.
But the attorney would explain to them, because the law gives the priority of who applies for the letters of administration. And you are very unlikely, the person who takes the children will not be the person in priority to apply for letters of administration.
Right.
And certainly, you know, I could get in a lot of trouble with child protection for just picking up these stupid children.
I agree. But because, I mean, even if you got permission from child protection, let's just say.
Yes, but I'm talking about the estate. I just made that as a side comment. But in terms of the estate, I do not have priority because the law speaks of who has priority.
Right.
So when you go to the attorney will still say you need to find a brother, sister, and so forth. If the person was married, is the wife to apply for the letters of administration, even though you're this good. And the children may not be the wife's children. They have relationships where the person may have had children, and then they later got married. So the wife is not the mother of the children.
More problems.
So in other words, it's easy if the wife is the mother of the children. Then she goes to apply for letters of administration, and the scenario becomes almost moot because there's no way I'm going to be able to take her children.
Right.
So that's why I put in that in the mix to add some context. It's very unlikely that a neighbor or someone, a busybody, go and take children to take care of if the person dies and the mother is there.
No, but that's what I'm saying. I deliberately use that scenario. The truth is, I have
situation in my mind. About it is the wife will be the person in priority to apply for the grant of letters of administration.
Right.
And after applying, they will go to investigation to find out the assets that the deceased person had at the time of the death. And like I said, it takes some doing, even when there is a will, because even when there is a will and you set it up, it takes some time. You have to go to the institutions. In other words, when you become the administrator or executor, it's a job. And in some places, people are paid for being the executor, especially if it's a large estate with lots of things to be distributed and different beneficiaries and trusts to be set up. It takes some doing. And even in England, a lot of times it's done by firms.
And it cannot be done before. Okay, so somebody...
it will be an inter vivos gift. Remember we mentioned sometime before, we may have forgotten. So just to go back a bit, if you have assets and you are concerned that when you die, there may be chaos in distributing them, you can make gifts while you're alive.
Right.
The problem with that, I often say, is that you have to be able to trust the people that you're making these gifts to. For instance, you have several pieces of properties, in one of which is your home that you live. And you have a few children, and you have, and you distribute you give the different children different properties, and you give one of them the house you live in. You do a deed of gift conveying it to them. That's a gift when you're alive, an inter vivos gift. What can happen? It often does not happen, because we like to believe that your children would have good intentions for their parent. But it can happen, and it has happened, where the child take the house, they probably mortgage it, they get a good life, and the parent end up suffering. And then when the parent try to talk to the child, they say, well, you can't do anything, you give me. And when the parent feels so distressed, they go to an attorney and say, I want to take back my gift, I want to take back the gift. And they cannot, because they cannot be reversed. The only way it could be... It cannot be reversed. What can happen is that the person who has received the gift can convey it back to the person who has given it. Yeah, but the person already want it and made all this confusion, so they don't want it. It's not going to happen. So you have to be very concerned. And that is why I always say it's better to do the will. The will, and be very clear with your gifts. Be very clear with your clauses, so that you eliminate the problems that can arise. I even spoke, I believe, to viewers some time ago about willing away harmony. Yes, because sometimes when they do the gifts, they try to create harmony in the family. And these types of gifts, sometimes it may be, people may live harmoniously, but sometimes it causes more conflict. Because you are trying to ensure that all your children staying in this house that they grow up in, they have different lifestyles, different viewpoints, they may have different partners. The children, they may not be able to get along with the other children, so the cousins are not getting along. And of course, people would take their sides, they would protect their little clan. And then conflict would arise, and the problem is managing that conflict now. So just going back on the letters of administration, the administrator would know, once you are appointed, you would now distribute the different assets that the person died in a similar way as an executor would. In terms of the paperwork, the difference will be that there's no will guiding you and telling you what goes to who. Instead, the Intestate Estate Act will tell you what goes to who. Well, it wouldn't tell you exactly what, because it would not spell out the different gifts. Yeah, of course. But it would tell you half share goes to the children, and you must find out what is the things that the person owns for this half share to go to the children. Jointly, right? In equal shares.
So that illustration that I was giving, where this person, even though they have someone, let's say brothers and sisters, their parents are, dead, so, but they have minor children, but as I said, they don't want to have anything to do, or didn't have anything to do with their siblings and so forth, or whoever else as their relatives, because the law or the act says whatever, regardless of who, whether it's a neighbor or friend, whoever is trying to be nice to help out the situation with the children, that does not matter.
Yeah, they would not have priority. They would not have priority to apply for a grant of letters administration.
So full stop.
Because in your applying, there is an administrator's oath. And the oath is something that is done under oath. Yeah. And it says your relationship. One of the paragraphs would give the relationship you had with the deceased. So you would itemize the person, the date of the death, the age, the different particulars, and you would say that you're one of the persons entitled to the estate, along with and you would name the other persons. So when you must put that paragraph in, and the registrar must be satisfied that you are a person entitled to apply for this grant of letters of administration. So if you are not the brother,
even if
when the registrar sees the paragraph, she's going to say, even if you're taking care of the children,
yeah.
then what is your relationship? There's no relationship under the Estate Act for you to apply, so you would not receive a grant.
Even if the children needs the help and whatever, and you understand what I mean?
No,
because
but that is a separate issue. The children would be taken. You would take care of the children as a good Samaritan, but you would not go and get. You would not be able to touch the money for you.
That's the point. Or for the children, that's what I'm saying. Because in the event
if there is
like
a trustee appointed.
No, there is none of that. I'm looking at our Grenadian content.
It is not going to happen.
It's not going to happen,
not
period.
Going to have access to the money.
Because why I'm raising
and
that.
it's a good thing too, because anybody could come and take the people's children.
I understand
estate.
that. But as I said, I'm deliberately bringing this in because we know our culture.
Right.
We do have these situations where people don't leave their house in order.
Yes.
A lot of the times, most of the times. And then is this person, because a lot of people grew up with some neighbor or some good friend that helped them out. And
I know people that had
the relatives
children,
who have nothing to do
like
with
a whole family of children living with them, and they had no children themselves, and they grew up 6 children who are brothers and sisters. They probably took the first one and realized, well, this one would not be able, it wouldn't make sense growing up without your siblings. So they take the others, and they didn't have any money per se for themselves. They fight up and they grow up the children. And you never know, because sometimes, people judge and they say who has money and who doesn't have money. But sometimes the person who has money doesn't even look like if they had a lot of wealth and spending all of this dough. And the children will grow up in utter poverty with somebody who is of little means, but they got food, but not luxuries. And they had a big fat bank account somewhere that they never found out about. Of course, the bank would, from time to time, publish accounts that are not they're dormant from time to time. So what the children may will be minors and they're not paying attention to that. But it's published, and if you want, you can find out if this person who died had this this dormant account, because when the account becomes dormant, eventually they would seize the assets. Banks after a while would seize assets for accounts that have not. I hope I'm not saying the wrong law on this point, but from what I understand, if your account is not been dealt with for a certain number of years, I think I'm saying the right thing, because I personally had the unfortunate incident where my account pretty much dried up. There would be charges and charges and charges on the account, and eventually it go dormant. They will probably write you a letter to tell you come and reactivate it, and if you do nothing, they will seize whatever is in it. Is left. They would treat it as an abandoned asset, right? I think there is some provision for that, which I'm not too familiar with it. The learning is there, and certainly I can read it, but I do know that at some point it will be you would not have access to it anymore, so to speak. So I'm not too sure, but it's a terrible situation.
Yes, it is. So everything goes right back to that will.
Everything goes right back to the will, and like I said, you can always just rely on the act, but oftentimes you may find, and let me give you another situation. In Grenada, we have the common law wife.
Oh boy.
Common law relationship. And you may very well be with your partner for 25, 30, 45 years, your whole life with this person. You never got married, you brought up your children, you had your grandchildren, and there was no will. The Intestate Estate Act does not protect you. It does not make provision for you. You are not a spouse.
Oh boy.
The law,
we need to say this again.
The Marriage Act tells you who is a wife.
Who is a wife, exactly.
This
needs to be clearly defined, because you see these issues. I mean, we're supposed to be talking more detail about the will, but
if you are not the spouse, then you are not entitled. So you must leave it to the good nature of the children you've had with this person. To do the right thing and ensure that you don't have to move out of the house that you brought them up in, because the estate, you know what will happen? All of the estate will go to the issues equally. The issues
oh,
are the children.
Oh my goodness, he said the issues.
Yes.
Yes.
So if they have 5 children,
from the man.
they came forth from the intestate.
So without a doubt, and I deliberately bringing this one in, those, I want to say this delicately on this, the women who are not married, they're not common law either, but they have relationship with.
Well, I think it's sociology, sociology and social studies and all these good disciplines. We would probably have like a visiting type arrangement.
And all of those, the bottom line is that only if a child may have come forth out of that relationship, only that child alone may have, well, not me, will have
the right to
any kind of right to access.
And it is providing as well that the child is recognized as a child of the person. Because with a woman, you're the natural child of your mother.
Yes.
But with a man, you are not, you are presumed. You are the presumed child, because you to prove it, there is a process.
Yes.
This is the other person. When you're born, they do the bedside registration, and your name is put in there. Or thereafter, you do an affidavit, and you get your name inserted on the records at the birth and death registry. But failing all of that, if you grew up and your father's name was never on your record, you must apply for an order for paternity at the High Court, which is a very expensive venture. And that again, you go to a lawyer, and we were talking some time ago about lawyers could be expensive. So then you have another cost. So something that was a cheap affidavit, now you have to have this expensive order for paternity. If the person dies, if the dad dies, you have to get resurrect the aunt. I have had the godparent swear affidavits, because you have to have people who are around who knew about the relationship with the woman.
Oh boy.
And oftentimes you search to find them, it will be their siblings. But remember, if you have siblings who might, sometimes the person is younger than the child themselves.
Right.
And they may be a sibling, but their niece or nephew might be 5 years older, and they did not know about the relationship at the time of the birth. So it's very ticklish sometimes to do it the other way around. And like I said, not advertising, I suppose, not paid advertising. But the best thing to do is really make the will. And I have a strong argument to say that people ought to, in preparation for their demise, their transition, they should make a will. It takes away a lot of
all this discussion
doubt.
we've been having.
It avoids problems. It helps you manage the loss that you have to face, because you're already dealing with the loss of your loved one. And then you have chaos to plan the funeral and this, and you don't know where funds are coming from. And the person may very well have an allocation in the bank for that. So it helps the process if you make a will and your loved one know, well, I have $20,000 there to go to LACWA in Co-op Bank or Republic Bank or whatever the case may be. And I want a happy hour, don't want a happy hour. Right, repast. And we like, we sorry, everybody know a happy hour. So, but for more viewers, you have the repast. And you want to ensure that everything is outlined and it helps your loved one, the ones you've left behind, for your transition. And that is why I really advocate it. If you have children and you were private and you probably did not want your siblings involved, you may have a trusted friend, or you may have an elder in your church, or somebody that you feel confident to, even though they're not your buddy. Or you can have a law firm appointed as your executors to manage the estate, in which case it's not personal at all, and you don't have to worry about anybody knowing your business, because they will treat it as business.
Of course.
Convey the title to who needs to be conveyed. They may be able to manage trusts and estates in a better way, more systematic and professional way. And so it's always best to make the will. And especially if you have minor children, create a trust for them.
We'll talk about that at the time.
I think we had discussed talking it briefly, but as a separate topic.
Okay, so, Naeisha, if I tell you the time, you will be amazed that
Yes.
we are that we have just a few minutes. But let's take a quick break, and then we would at least attempt, and I have to say attempt, to go back to at least the part of the will where we got to
Yes.
the last time. So
Yes.
let's take a quick break, and we are going to be right back.
You are my strength.
Every session of the Second Vatican Council began with the prayer, Ad Sumus Sancte Spiritus. The first word of the Latin original meaning, we stand before you, Holy Spirit, which has been historically used at councils, synods, and other church gatherings for hundreds of years, being attributed to Saint Isidore of Seville. As we are called to embrace this synodal path of the Synod 2021 to 2023, this prayer invites the Holy Spirit to operate within us so that we may be a community and a people of grace.
We stand before you, Holy Spirit, as we gather together in your name,
with you alone
to guide us. Make yourself at home in our hearts. Teach us the way we must go and how we are to pursue it.
We are weak and sinful.
Do not let us promote disorder.
Do not let ignorance lead us down the wrong path.
nor partiality influence our actions.
Let us find in you our unity,
so that we may journey together to eternal life,
and not stray from what is truth and what is right.
All this we ask of you, who are at work in every place and time,
in communion of the Father and the Son,
forever and ever.
Amen.
You are my strength.
Well, thank you very much for staying with us. Oh my, I wish we had 2 or 3 hours. But that's all right. We will continue another time. For those of you who would have just joined us, I am chatting with Naeisha this morning. Again, we are talking wills, my goodness. And it's just so much to talk about. But, Naeisha, we are going to go ahead with at least where we left off the last time.
Yes.
Which was, you know, the kind of wording, and if the person gets to the lawyer, what it is that they should expect, how this whole will thing is going to sound. So,
right. So I'm just going to, I think when we started, I might have given you just a little bit on the introduction. I'm going to reread how the will begins and what it says.
Yes.
And then I'm going to see how far into the paragraphs of the will we can go.
Yes.
I think we did speak about some formalities
Yes.
earlier. And at some point before we end all of these sessions, I will go back to give you the formalities again so that we can make it a little bit clear in everybody's head, because we've had some long breaks in between. So reads like that. This is the last will and a testament of me, and you state your name, Naeisha John, and I, Naeisha John of Mount St. Ovens, in the parish of St. Andrew in the state of Grenada, being of sound mind and testamentary disposition, and or you can say sound mind and memory. Different people may have different coins that they use as attorneys. Some attorneys may not even put in that line. They will make the assumption that you're of sound mind, right, and your memory, and you're able to make this will, this testamentary disposition. And some of these words I may have to explain to viewers, I think. Make this my last will and testament. And you would have a next clause where you revoke your former wills. I hereby revoke former wills, codicils, testamentary dispositions, and declare this to be my last will.
Right.
And I would have mentioned, I think, that the last will is always taken as a valid will.
Yes.
So anyone before in time will not be valid anymore. Okay? And then you have the clause where you appoint your executors. I hereby nominate, appoint, and constitute Wendy Ruffin to be the executrix, because it's female, executrix of this my last will and testament, executor for male. Okay?
Yes.
And we go on. And if you have a trust that you want to create, you will appoint and constitute, nominate, appoint and constitute another person.
Or the same person.
Or the same
one.
person.
Okay.
It can definitely be the same person as the trustee for your last will and testament. Okay?
Okay.
So
that is it.
Right? We go back to talk about the memory. You must have proper memory when you're making a will, because that speaks to your state of mind.
Right.
So for instance, if you have Alzheimer's, there is that question mark. And I say a question mark because you may have a lucid interval. And once you have a lucid interval, your clarity of mind, you can make a will. It doesn't stop you from making a will.
Right.
But of course, if your Alzheimer's is gone and you have no lucid intervals, then your mind and memory would not be there so as to make a will. And it goes to whether you have the ability to make a will.
So. Right.
Testamentary disposition. You must know that you want to make a will, have the intention to make the will, right? So, and they must all be coupled with the ability to make the will or capacity to make the will.
Okay.
Right? So all the things like your age, you know, a minor, for instance, would not be able to make a valid will. If you are insane, you would not be able to make a valid will. And other things like that could vitiate or prevent you from having a valid will.
Right.
If you're intoxicated, it will affect your capacity. So if you know some people have problems with alcohol, they would go to an attorney and they want to make the will, and the attorney will go, whoa, I can't make that will. I cannot take your instructions. Can you come back this evening at 4:30? And you come back at 2:30 and you're not. So you say, okay, well, let's come first thing in the morning. Okay, first thing in the morning, Mr. John, first thing in the morning at 8.
Okay.
And at 8, you come again, and they will say no, because they did not do a breathalyzer, but if you are obviously seeming that you're not coherent and you have had a lot to drink and you can smell alcohol coming from you, a lawyer is likely to say, this person is intoxicated. Can I really justly take instructions from them, proper instructions to take to make a will? Do they have the disposition? Do they have the capacity? Is their mind affected by the alcohol consumption that they've had?
Right.
And these are the questions the attorney must satisfy themselves before they can go ahead to make a will. Your mental element. Are you having a lucid interval? Are you okay? Are you not okay? If someone is suffering from a disease which may affect their mind, mental memory, I always ensure that I have a doctor present when I'm taking the instructions. So I would call a doctor, tell the family, listen, you make contact or I will make contact. It's up to you. And we'll have, if there's a family doctor, I just make contact with an attorney and with a doctor. I show up with my doctor present and let them check the person to see whether this person is okay, and I can take the instructions. And usually I would take the doctor back when I'm going for signatures. If I am doing it, usually that would happen outside the office. You know, if somebody's informed, doesn't mean that they cannot make a will, because their mind and their memory is intact. And once it is intact, your physicality, if your signature cannot be done, then you can put your mark.
Right.
And so you may want to have somebody attest to their mark. So you'll have a special, your witness would have to attest to the signatures, and that the person was not able to sign it, did a mark. You can probably have an official attester present to ensure that that witness can corroborate the person, in fact, is the one, the maker of the will, and place their mark, signature, thumbprint, fingerprint or so on the document, because that can serve as a valid execution of a will. Okay? So then we're talking a little bit about your mind and your testamentary disposition, and then we went on to talk about revocation. Revocation as the intention to make the will must be there. You must intend to revoke your former will. So some of these words are a bit loaded, I would say, because they carry them a certain mental state.
Right.
It is not just the act of doing the thing, but it's the mindset of doing the thing.
Right.
So you intend to make the will and you intend to revoke your former wills. Okay, so it's coming with that intent, and that's why I'm saying you must be of your right mind. Because if you're not of your right mind, you may not have revoked your former wills, because this will may not very well not be valid, even though you're writing, you're revoking. And if it's not valid, your previous will would be the valid one.
Right.
Okay. Then we spoke about the job of the executor. We spoke about the job of the trustee. If a trustee is set up to, for certain things, a charitable purpose, philanthropic purpose, religious purpose, to take care of minors and other such things. For education or other purpose, you will have this person manage that fund, okay? Invest and so forth. And we had a whole topic to talk about just trust and different types of trust, right? And then we went on to talk about the debts. After all of my just debts and funeral expenses are paid, I make the following gifts, device, and bequest. Any debt that is outstanding becomes a debt of the estate. So a personal debt now becomes a debt that the executor, executrix must handle.
Right. And that is, and when you say that, whether that debt is personal or business, once it's in their name.
I'll stick a little pin. Business, yes, but if it is a company that is a limited liability company, the debt will not attach to the company because the company under corporate law has legal personality. It is seen as an entity, just as a person.
Yeah.
All right. But, right. Okay. So the company itself, but if you have a firm, right, a business name or a firm, then those debts will attach to the estate. Okay. And then we spoke about the funeral expenses that has to be taken care of first. The debts have to be taken care of first before you start distributing to the different people who have to get. And if you have cash, that is what comes out first to pay these debts. But if there's no cash after you've checked your the accounts and you've done all your diligence searches, you realize this person's account dried up. They only have $5,000, $2,000, $500 in the account, then you must start to liquidate. So that somebody who may have originally been a person who receives land, the land has to be sold by the estate in order to get cash to pay those debts. The person who has lands is called a legatee, right? The owner of land, okay? Right. And so we went on to say, you are making you're making devices, gifts, bequests, and gifts. And I want to highlight a device to be a gift of land, real property.
Right.
And any other type of gift is called a bequest. That is of a phone, of a nice mug, of some china, beds, other chattels, animals. All of that will form under.
Once it's not land.
Once it's not land, okay? Once it's not realty, okay? And it's personality. I think we talked about personality.
Yes, we did.
And we had a joke because we said it's not personality, it's personality. There's no I, okay? And then we went on. We didn't go on. I think that is just about where we stopped.
So we take that last point that you will now introduce.
The new introduction is,
and then
I like to give a description of what you own. So it's clear. So I would say I'm the owner of this lot of land situated at Bellevue in the parish of St. Andrew or St. David's or wheresoever, measuring 10,890 square feet, and I'd like to convey this property. There's some specific words which you said. I give and devise, because it is a gift of land, to Wendy Ruffin, right, for her absolute use and benefit, right? So she gets that land in its entirety, right? And the interest she's getting is a fee simple interest, absolute use and benefit. Those words mean fees, and she's getting a fee simple interest. And we have to go through what exactly is a fee simple. So just a few sessions ago, I would have explained what land was.
Yes, we did.
So just by way of recap, a fee simple interest is the most permanent form of land ownership that you can have.
Right.
And once you own land in fee simple, you can dispose of it, sell it, will it away. You can rent it. If you rent it, the person who rents it is a tenant. It's a lease arrangement, and they have a lesser interest in the land than you have. They would have a leasehold interest. You are holding the land in what we call the fee simple interest, which allows you to alienate, sell, and so forth, mortgage, and so on, okay? And you do not account to anyone for it.
Right.
Okay? So that's a fee simple interest that you will own.
Okay.
All right?
Well, our time
I see that I've
It's
only
amazing.
given you
We
one example in one clause, and it's a new point.
At least we've gotten there.
So I hope viewers found this interesting. They have the recap. We spoke a bit about what happens if you didn't have a will and the urgency to prepare your will, whether or not you are a young person, 21, 22, 25, 30, or whether you're an older person, chronologically, of course.
Yes.
You might be 80, 90, 50, 60. You may be informed or you may be very well. And that should not matter to you once you have the capacity to make a will.
And you have
and you
assets
must
to
go
will away.
sober. Even if you've had a drink, you must ensure that you've gone in to do your will in a sober state of affairs and you've had the intention to make your will. It's always good when you're going to see an attorney to make a will to list your items in your private time.
Right.
Because oftentimes when you're in the office, you can miss something you have. I also encourage clients to walk with their documents. It doesn't have to be an original paper, but just so that I can itemize it in the document so that it leaves less guesswork for your executor. And it's not absolutely necessary for a lawyer to describe your will, you know, your assets in your will. Some lawyers may be listening to me and saying, but why I do this and this is not necessary and so on. It is my view that it helps the person, and I'm always about getting the best outcome for my client, even though the client is going to be dead at some point when this other person is looking at the document. But I think I owe it to my client and respect for my client to ensure that their business is handled very well and is very clear when they've gone what it is, what their true intention.
Right. Clarity
and harmony.
Naeisha, well, one thing I would say is this. We will ensure that we start the next program exactly on this point.
Yes.
But it was really good. And I do believe that the recap, as well as the, it might not have looked so much as additional information, but where we started to talk about earlier, I really believe that that was or is very necessary for people to really just get their whole, frame of mind in the place of, this thing is really important. Yes. And even if one person has listened or viewed us today, and they're like, you know what, I've had this thing on my mind for a while and I really think I need to just get it done, then it means that that program was for them and they would have benefited. So, thank you again for coming.
Thank you. Always a pleasure.
Definitely. Always a pleasure having you. Listeners and viewers, thank you very much for being with us today. God's richest blessing and grace upon you for the rest of the day and for the weekend. God bless you and goodbye.
You are my strength like no